The objective of many of these laws or schemes is to confer or provide entitlements based on individual earning and contribution. For example, Provident Fund is payable due to the employee's personal contribution and status as employee. Similarly, objective entitlement of benefits of employees' state insurance, etc., flow from individual status, work, and effort. Major part of these benefits, or all of them, flow in the event of certain eventualities such as fatal accident or death. The design of these statutes and schemes is to enable both the concerned subscriber or the employee to receive them, or in an unforeseen event such as death, for his dependents to receive them. The restrictive way in which dependent or nominee excludes their enjoyment to the intended beneficiary. Addressing all these aspects and concerns means considering a range of policy choices and involving multiplicity of legislative architecture governing the regulations guided by diverse interests and concerns, many of them possibly coalescing. On 3rd of May 2023, during the course of the hearing, the learned Solicitor General, upon instructions, had expressed the Union's position that a high-powered committee headed by the Union Cabinet Secretary would be formed to undertake a comprehensive examination to consider such impacts and make suitable recommendations in that regard. So we proceed to agree with the learned Chief Justice's conclusions with regard to the right of transgender persons in heterosexual relations to marry under existing laws. On the issue of adoption, we express our disagreement and voice our concerns in the following manner. We have voiced our concerns and laid it out in some detail, which I do not wish to read. This is not to say that unmarried couples, whether queer or heterosexuals, are not capable or suitable to be adoptive parents. However, once the law permits, as it has done, adoption by both single individuals, likelihood of their joining and cohabiting cannot be ruled out. In such event, de facto family unit can and does come about. The underlying assumption in the law as exists is that such unmarried heterosexual or queer couples should not adopt. It needs to be closely examined. Similarly, the needs of such couples to have and raise a family in every sense of the term has to be accommodated within the framework of the law. The existing state of affairs which permits single individuals to adopt and later live as a couple in exercise of their choice, in effect deprives the children of such relationships various legal and social benefits which are otherwise available, given the objective of to a married couple. In other words, given the objective of Section 57, the state as parents patria needs to explore every possibility and not rule out any policy or legislative choice to ensure the maximum welfare and benefits reach the largest number of children in need of safe and secure homes with a promise for their fullest development. Response to the learned Chief Justice's comments on our draft, which I propose to read, part of which I propose to read. This court's observations with respect to the learned Chief Justice's reasoning centered around the enunciation of the bouquet of rights emanating from various provisions and locating an obligation has to be seen in the backdrop of the unanimous view of this court that the fundamental right to marry is not found within the Constitution. Therefore, it is our considered opinion that to create an overarching obligation upon the state to facilitate through policies the fuller enjoyment of rights under Articles 19 and 25 is not rooted in any past decision or jurisprudence. That queer couples have the right to exercise their choice, cohabit and live without disturbance is incontestable. In the same vein that they are owed protection against any threat is the natural corollary of their right under Article 21. Consider in this context also the nature of relief sought. and the positive obligation fashion. Whilst there are innumerable judgments on the positive contents of the rights under Article 21, there are countless judgments that insist upon the separation of powers when it comes to matters of policy and the courts not being the appropriate forum for adjudication of the same. The polycentric nature of this issue is compelling. Next, as to the reasoning that our conclusion on the challenge of SM and subsequently finding on the disparate discriminatory impact faced by the queer community, a small comment is called for. The section discussing the provisions of the SMA and the challenge to its validity was based upon whether it violated the Constitution on the ground of impermissible classification under Article 14, for which the object of the Act to facilitate marriage between interfaith couples, wherein at the time marriage or even a couple only denoted heterosexual couples in the light of same-sex relationships being criminalized, and its provisions are relevant factors. Classification involves differentiation. Further, this court has discussed how underclassification per se does not warrant invalidation. In contrast, in the later segment on discriminatory impact, the issue that this court was considering was not reasonable classification, but impact upon queer couples through neutral laws or regulations that they encounter in their everyday lives, the purpose of which or even their substantive provisions have nothing to do with marriage. It is rather to confer other benefits, many of which are earned or accrued on account of individual skill. Yet the framing of these benefits or their intended beneficiaries were articulated in terms of entitlement to families or spouses, tends to exclude from its ambit queer couples. When such queer couples are entitled to benefits wherever they fulfill other eligibility criteria, it is the disparate impact of these neutral laws in the disbursement of entitlements or benefits which is seen through the effect or impact lens. Therefore, the discussion on constitutionality of SME is markedly different from the section on discriminatory impact in certain points for queer couples, as they have no avenue for marriage like heterosexual couples. In the latter, the impact of various laws were pointed as starting point for the state to take remedial action. Be sorely mistaken if we presume what the queer community in all its diversity seeks and lays it out as a formaic framework. Many may welcome civil unions as a pragmatic first step, while some may find it yet to be another inequitable solution to the feeling of exclusion that persists in society against this community, and one which simply repackages the stigmatization felt. Many may desire marriage as understood in the traditional sense to escape their societal realities, a form of financial and social emancipation from opposing natal families, or diametrically opposite, to assimilate and gain more social acceptance. Yet others may, as a result of their experience, reject altogether the institution of marriage and all the social obligations and associations that come with it, but still want protection of their rights. Certainly, what the former group may want does not hamper or hinder the latter in any manner, for it is a choice that they seek. That the state should facilitate this choice for those who wish to exercise it is an outcome that the community may agree upon. Yet the modalities of how it should play out, what it will entail, are facets that the state, here the legislature and the executive, needs to exercise its powers in furtherance of. Now, whether this will happen through a proactive action of the state or as a result of sustained public mobilization is a reality that will play out in India's democratic stage, and something only time can tell. The state may choose from a number of policy outcomes. They may make all marriage and family related laws gender neutral, or may create a separate SMA-like statute in gender neutral terms to give the queer community an avenue for marriage. They may pass an act creating civil unions or a domestic partnership, among the many other alternatives. Another consequence may be that rather than the union, the state legislature takes actions or enacts law. What is, however, certain is that in question of such polycentric nature, whether social or political, the court must exercise restraint and defer to the wisdom of the other branches of the state, which can undertake wide-scale public consultation, consensus building, and reflect the will of the people and be in their best interest. If as a result of this, a law is enacted that undermines or violates the constitutionally protected rights of an individual, no matter how minuscule, their right to seek redressal from this court is guaranteed. That the petitioners seek what many of us may deem to be normal or accepted next step in the life upon attaining a certain age, and perhaps take for granted is not lost on us. Their desire for social acceptability in the manner that has been historically known, through the social recognition that marriage affords, and the lack of which causes them the feeling of exclusion and hurt, is one that, as individuals, especially donning the robes of justice, we can certainly have deep empathy with. However, we are deeply conscious that no matter how much we empathize with the outcome sought, the means to arriving at such a destination must be also legally sound and keep intact the grand architecture of our constitutional scheme. If we throw caution to the wind, we stand at the risk of paving the way, wherein each brick may feel justified to untold consequences that we could not have contemplated. While molding relief as a code, we must be cognizant that despite being empowered to see the capabilities of the law in its grand and majestic formulation, we must not be led aground because we are blinded by its glow. Now I pass on to read the conclusions and the final directions that we have summarized. The court hereby summarizes its conclusions and directions as follows. There is no unqualified right to marriage except that recognized by statute, including the space left by custom. 2. An entitlement to legal recognition of the right to union, akin to marriage or civil union, or conferring legal status upon the parties to the relationship can be only through enacted law. A sequitur of this is that the court cannot enjoin or direct the creation of such a regulatory framework, resulting in legal status. The finding in 1 and 2 should not be read as to preclude queer persons from celebrating their commitment to each other or relationship in whichever way they wish within the social realm. 4. Previous judgments of this court have established that queer couples have a right to union or relationship, be it mental, emotional, or sexual, flowing from the right to privacy, right to choice, and autonomy. This does not, however, extend the right to claim a legal entitlement to any legal status for the said union or relationship. The challenge to SMA on the ground of underclassification is not made out. Equality and non-discrimination are basic foundational rights. The indirect discriminatory impacts on relations in relation to earned or compensatory benefits or social welfare entitlements to which marital status is a relevant eligibility criteria for queer couples who exercise choice to form relationships have to be suitably addressed and removed by the state. These measures need to be taken with expedition because inaction will result in injustice and unfairness with regard to enjoyment of these benefits available to all citizens who are entitled and covered by such laws. As held earlier, this court cannot, within the judicial framework, engage in this complex task. The state has to study the impact of these policies and entitlements. Consistent with the statement before this court during the course of the proceeding, the union shall set up a high-powered committee chaired by the Cabinet Secretary to undertake a comprehensive examination of all relevant factors, especially including those outlined above. In the conduct of such exercise, the concerned representatives of all stakeholders and the views of all states and union territories shall be taken into account. The discussion on discriminatory impacts is in the context of effects of the existing regimes on the queer couples. When a heterosexual couple's right to live together is not contested, the logic of the discriminatory impact faced by queer couples cohabiting together would definitionally, however, not apply to them. Transgender persons in heterosexual relationships have the freedom to and entitlement to marry. Regulation 5.3 of CARA regulations cannot be held void. At the same time, the court is of the opinion that CARA and the central government should appropriately consider the realities of de facto families where single individuals are permitted to adopt and thereafter start living in a non-matrimonial relationship. In an unforeseen eventuality, the adopted child in question could face exclusion from the benefits otherwise available to adopted children of married couples. This aspect needs further consideration, for which the court is not the appropriate forum. Furthermore, the state shall ensure, consistent with the previous judgments of this court, that the choice exercised by the queer and LGBTQ couples to cohabit is not interfered with, and they do not face any threat of violence or coercion. All necessary steps and measures in this regard shall be taken. The respondent shall take suitable steps also to ensure that queer couples and transgender couples are not subjected to any involuntary medical or surgical treatment. The above directions are in relation to transgender persons are to be read as part of and not in any manner whittling down the directions in NALSA, supra, so far as they apply to transgender persons. The directions are disposed of in the above terms.
View of Brother Ravi Bhatt, as stated in the judgment.
I am conscious of the ordeals that arise from multiplicity of judicial opinions in cases involving constitutional questions. Yet I consider it worthwhile to pen the present opinion given the significant nature of the questions involved. Polyvocality in the exercise of adjudicatory function may not necessarily be viewed with discomfort if complemented with judicial discipline. It is truly reflective of diversity of judicial thought. At the very outset, I have given my conclusions while agreeing with the opinion of Justice Bhatt. I will read the conclusions. The question of marriage equality of same-sex LGBTQ couples did not arise for consideration in any of the previous decisions of this court, including the decision in Navtej Nalsa. Consequently, there cannot be a binding precedent on this court. The reasons for arriving this conclusion are articulated in detail with Justice Bhatt. The rights of LGBTQ persons that have been hitherto recognized by this court are the rights to gender identity, sexual orientation, the right to choose a partner, cohabit and enjoy physical and mental intimacy. In the exercise of these rights, they have full freedom from physical threat and from coercive action, and the state is bound to afford them full protection of law in cases these rights are in peril. Third, there is no unqualified right to marriage guaranteed by the Constitution that qualifies it as fundamental right. I have given my detailed opinion. In one paragraph, I would read that. In my considered opinion, the institutional space of marriage is conditioned and occupied synchronously by legislative interventions, customary practices, and religious beliefs. The extant legislative accommodation of customary and religious practices is not gratuitous and to some extent conditioned by the right to religion and right to culture, constitutionally sanctified in Article 25 and 29 of the Constitution. This synchronously occupied institutional space of marriage is a product of our social and constitutional realities, and therefore, in my opinion, compared to judicial perspectives, offer little assistance. Given this nature of marriage as an institution, the right to choose a spouse and the right to a consenting couple to be recognized within the institution of marriage cannot but be said to be restrictive. Coming back to the conclusion, right to marriage is a statutory right, and to the extent it is demonstrable, a right flowing from a legally enforceable customary practice. In the exercise of such rights, statutory or customary, the state is bound to extend the protection of law to individuals so that they can exercise their choices without fear and coercion. This, in my opinion, is the real import in the decision in Safin Jahan and Shakti Vahani. The constitutional challenge to Special Marriage Act 1954 and Foreign Marriage Act must fail for the reason indicated in the opinion of Justice Bhatt. Similarly, Justice Bhatt also rightly finds the semantic impossibilities of gender-neutral constructions of the Special Marriage Act and Foreign Marriage Act. On both E and F of his opinion, Justice Bhatt has exhaustively as to the reasons that they need not now be supplemented. I find no right to civil union or an abiding cohabitational relationship conferring a legally enforceable status cannot be situated within Part 3 of the Constitution. On this count, I too agree with Justice Bhatt, but I have supplemented it, in my opinion, having considered that there exists no unqualified right to marry. In the ordinary course, no occasion would have arisen for any further deliberation. However, as the learned Chief Justice, in his opinion, has arrived at a conclusion that there exists a constitutional right to a union or an abiding cohabitational relationship, it is necessary for me to express my opinion on this newfound construction. The learned Chief Justice locates components of the right to union or an abiding cohabitational relationship under Articles 19(1)(a), C, E, 21 and 25 of the Constitution. In my opinion, it would not be constitutionally permissible to identify a right to a union or an abiding cohabitational relationship mirroring the institution of marriage. The learned Chief Justice identifies tangibles and intangible benefits, that is, bouquet of entitlements that arise from state recognition and regulation of marriages. The Chief Justice further opines that the right to marriage is not fundamental. However, it is in these tangible and intangible benefits, the denial of which, according to the learned Chief Justice, must inform the reading of a constitutional right to an abiding cohabitational union. In other words, the benefits of marriage, however fundamental to a fulfilling life, do not make marriage itself a fundamental right, but they render the right to an abiding cohabitational union fundamental. I find it difficult to reconcile these two principles. I finally conclude, I will read the last two. I also agree with the reasoning and the conclusions of Justice Bhatt with respect to constitutionality of Regulations 5(3) of CARA regulations. I have concluded with what I strongly feel. I am not oblivious to the concerns of LGBTQ partners with respect to denial of access to certain benefits and privileges that are otherwise available only to married couple. The general statutory scheme for the following benefits, gratuitous or earned, property or compensation, leave or compassionate appointment, proceed on a certain definitional understanding of partner, dependent, caregiver, and family. In that definitional understanding, it is no doubt true that certain classes of individuals, same-sex partners, live-in relationship, and non-intimate caregivers, including siblings, are left out. The impact of some of these definitions is iniquitous and sometimes discriminatory. The policy considerations and legislative frameworks underlining these definitional contexts are too diverse and to be captured and evaluated within a singular judicial proceedings. I am of the firm belief that a review of the impact of the legislative framework on the flow of such benefits requires a deliberative and consultative exercise, which exercise the legislature and executive are constitutionally suited and tasked to undertake.
Thank you very much.
Thank you.
Helps beat sensitivity fast. Sensodyne Rapid Relief.
Are you ready for crystal clear visuals with immersive sound at unbeatable prices and easy EMI options? This Cricket World Cup brings stadium home with Electronic Smart.
One cannot join issue. Equally, if by some state process, measures or conduct has been barred from expressing one's choice publicly, the reasonableness of that prohibition or order can be tested on grounds enumerated in Articles 19(2) and other grounds. However, when the law is silent and leaves the parties to express choice, Article 19(1)(a) does not oblige the state to enact a law or frame a regulation that enables facilitation of that expression. All judgments of this court were based on effects of laws or policies based on statutory provisions. Equally, in the absence of a legal framework enabling citizens to form a particular kind of association, as
And
for
the community
instance,
consists of
recognition
inter
of a
alia
limited
transgender men
liability
and
partnership,
transgender women.
which was not
A
recognized
transgender man has the right to
and
marry a
given
woman under the
legal
laws governing
status
marriage
till
in the
recently.
country,
The
including
court could not
personal
have
laws.
validly created
Similarly,
the
a
regime by
transgender woman has the right to marry a
enabling
man.
recognition
A
or
transgender
regulating
man
such
and a
associations.
transgender woman can also
Similarly,
marry.
the absence of
Intersex
any
persons who
enacted law
identify as a man or a
which,
woman and seek to enter into a heterosexual marriage would also
enables
have a right to marry. Any other interpretation of the
facilitation of
laws governing
transport.
marriage
It
would
is
be
hard to
contrary to
visualize
Section 3 of the
that a
Transgender
citizen can
Persons
approach
Act
the
and
court
Article
and seek
15
the
of the
construction of the
Constitution.
road to enforce the right to travel.
Now,
Or
we've gone
seek
to
the
the
court's
Khara
intervention to
regulations.
create a network of roads.
Regulation 5
Likewise,
of
the
the
absence
adoption
of basic
regulations, and
housing.
I've said that Regulation 5
Again,
of the
the
adoption
court, if
regulations
approached for
exceeds the scope
enforcement
of
of
the JJI.
19(1)(e),
However,
would not call upon the
Regulation
state to create
5(3)
one by
of the
either
adoption
framing a general
regulations
legislative
bars
policy
unmarried
or
partners
through law.
from being prospective
Furthermore, this court
adoptive.
has
Couple
written
is
the
married and the
learned Chief
consent of both the
Justice's
parties shall be secured.
opinion.
However, Regulation 5(3) in express terms excludes
There is no
unmarried
difficulty
couples from
about the right
adopting
of two
by
consenting
prescribing the condition
persons to decide to
that the
live
couple must have
together
been in 2 years
to
of a
cohabit
stable
and
marital
create the
relationship.
unique idea of home,
210.
unconstrained by what
As
others
observed
say.
in the previous
This is
paragraph,
the
the
sequitur
JJ
to
Act does
Kutswami
not,
and
the Juvenile
Navtesh.
Justice Act does
Conduct
not
hitherto
preclude
criminalized is
unmarried
now
couples from
permissible.
adopting.
The
Though
liberative
Section
effect
57 of the
section
Act
being
grants CARA the power to
3377
prescribe
being
additional
read down
criteria.
is that
The
two
criteria must
individuals,
not exceed the scope of
regardless
the
of their
legislative
sexual
policy.
orientation,
Neither the
are
general
enabled to
principles
live
guiding the
together with
JJ Act nor
dignity
Section 57
and
in
also
particular
protected from any
preclude
kind of
unmarried
violence
couples
for
from
living and
adopting a
existing
child.
together.
In fact, all the other
Therefore, the
criteria
right to be
ensure the
left
child's
alone, the
best
right to
interest.
exercise
The
choice,
Union of India has
right to
not
dignity
proved
and
that precluding unmarried
live
couples
one's
from
life
adopting a child,
with the
even though
person
the
of
same
one's
people are
choice,
eligible to
is an
adopt in their
intrinsic
individual
and
capacity,
essential feature
is in
of
the
Article
child's best
21.
interest. Thus, CARA has exceeded its authority by prescribing an additional condition by way of Regulation 5(3), which is contrary to the tenor of the
Even if you
Juvenile
want
Justice
to,
Act
for
and
argument's sake,
Section
recognize
57
an
in particular.
entitlement under the Constitution to enter into
The
an
adoption
abiding
regulations
cohabitational
use
relationship or
marriage as a
union.
yardstick to
In our
classify
opinion, it
couples.
cannot
There is an
follow
intelligible
to a claim
differential
for
in
an
using marriage as an
institution.
indicator to
There are
classify couples
almost
in the sense
intractable
that
difficulties
married
in
couples can
creating
easily be
through
distinguished from
judicial
unmarried
orders
couples.
or diktat, a
However, the
civil right
differential
to
does
marry
not have a
or a
rational
civil
nexus with the
union,
object sought to
no
be
less
achieved by
of
the
the
CARA
kind
regulations,
that is sought
which is
by
to
the
ensure that the
petitioners.
best interest of the child is
Ordering a
protected.
social
Placing a
institution
child in
or
a stable
rearranging
family
existing
is
social
undoubtedly in
structures by
pursuance of a
creating
child's
an
interest.
entirely
However,
new
the
kind of
respondents have
parallel
not placed
framework
any data on the
for
record to support
queer
their
couples
claim
would require
that only married
conception of an
relationships
entirely
can provide
different code,
stability.
a new
It is true that
universe of
separating
rights
from a
and
married
obligations.
partner is a
This will
cumbersome
entail
process
fashioning
when
a
compared
regime
to
of
separating
state
from a partner
registration
with
of
whom a
marriage
person is in a
between
given
queer
relationship.
couples.
This
The
is because
conditions for
separation
a
from a
valid
married partner is
matrimonial
regulated by the
relationship
law, while
amongst
live-in
them,
relationships
spelling
are
out
unregulated
eligibility
by law,
conditions
other than for
such
the
as
limited
minimum
purposes
age,
of domestic violence.
relationships which fall
For
within
instance, the law
prohibited
deters a
degrees,
person
grounds
from
for
securing a divorce
right to
immediately by
maintenance,
prescribing conditions
alimony,
such as a
etc.
6-month waiting period after a petition for divorce by
The
mutual
learned chief,
consent is filed.
as a result,
Merely
with due
because a
respect,
marriage is
we are unable
regulated
to
by the
agree with
law,
the
it
conclusions
cannot
of
be
the learned
assumed
chief
that marriage
justice
alone
with
or
respect
that
to
every
tracing the
marriage
right to
records
enter
stability
into
to a
or
relationship.
form unions from the right
Similarly, it
of
cannot
freedom
also be
of speech and
inferred
expression,
that the
the
couples
right
who
to
are
form
not in a married
associations along with
relationships
right
are not serious about the
any other
relationship.
corresponding
The stability
positive
of the household
obligation.
depends on
It
various
is
factors,
reiterated that all
such as
queer
the effort
couples
and
have the right to
involvement of the
relationship
partners
and
in
choice of
establishing and
partner,
running a
right
household,
of
creating a
cohabitation
safe
as an
space at
integral
home,
part of
creating
choice
a healthy work-life
linked to their
balance,
privacy and
and a
dignity.
household where mental,
Any further
physical, and
discussion on
emotional
the rights
violence
which
is not inflicted on one
consenting
another.
partners may
There is no
exercise is
single form of a
unnecessary.
stable household.
No one
There is
has
no material on the
contested
record to prove
that two
the
queer
claim
couples
that
have
only
the
a
rights
married
enumerated
heterosexual
under
couple would be able to
19(1),
provide
Articles
stability to the child.
91A,
In fact, this
C
court has
and D,
already
or
recognized
even the
the
right to
pluralistic
conscience
values
under
of our
Article
Constitution,
25.
which
The
guarantee a right to
elaboration of
different
these
forms
rights to say
of
that the exercise
association.
of choice to such relationships renders these meaningful, and that the
Regulation
state is
5(3),
obligated to
though
recognize
facially
a
neutral,
bouquet of
indirectly
entitlements
discriminates
which
against
flow from such
atypical
abiding
unions, such as the
relationships
relationship
of this
between
kind is not
non-heterosexual
called for.
partners, which
We
have not
therefore
been recognized
respectfully
by the
disagree
state.
with that part of the
Queer
learned Chief
marriages have not
Justice's
been recognized by the
reasoning,
state,
which
and queer
forms the basis
persons
for
in
some of the
atypical
final
unions
conclusions and
cannot yet
directions
enter into a marriage which
recorded
is
in this
recognized by the
judgment.
state. Though the additional criteria prescribed by the adoption regulations would also affect a heterosexual person's eligibility to adopt a child, it would disproportionately affect non-heterosexual couples. This is because the state has not conferred legal recognition to unions
Agree
between
with
queer
the
persons in the
conclusions
form
of the
of
learned
marriage.
Chief Justice with respect to
Consequently,
the
an unmarried
inapplicability of
heterosexual
the
couple who
SMA.
wishes to adopt a
We
child
also
has the option of
add,
marrying to meet
certain
the
observations.
eligibility criteria
Gender,
for
a
adoption.
gender-neutral
However, this
interpretation
option is not available
of
to queer
SMA
couples.
and its
When
provisions,
Regulation
much
5.3 is
like many
understood in the light
seemingly
of this
progressive
position,
aspirations,
a queer person
may
who is
not
in a
really be
relationship can
equitable
only
at
adopt
times
in an individual
and can
capacity.
result in women
This
being
exclusion
exposed to
has the effect of reinforcing the
unintended
disadvantage
vulnerability,
already faced by the queer
especially when
community.
genuine attempts are made to achieve a balance
The
in a
law
social
cannot make
order
an
that
assumption
traditionally
about
was
good
tipped
and
in
bad
favor of
parenting
cis
based on the
heterosexual
sexuality of
men.
individuals.
The purpose
Such an
of the
assumption
terms like
perpetuates
wife,
a stereotype
husband,
based on
man and
sexuality
women in marriage
that only
is to
heterosexuals are
protect
good
the
parents and
socially
all other parents are bad parents,
marginalized
which is prohibited by Article
demographic of
15.
individuals.
This assumption is
For
not different from the
instance,
assumption
women
that
facing
individuals of a
violence by
certain
their
class
partner
or
have a
caste
right
or
to
religion
recourse
are better
under
parents.
the Domestic
In view
Violence
of the
Act,
above
which
observations, the
assures
adoption
and is meant to
regulation
assure
is violative of
that
Article
the victims are
15 for
safeguarded and
discriminating
provided
against the
relief.
queer community.
In fact, provisions of SMA for alimony, maintenance, confer
According to the
rights to
adoption
women.
regulations,
Likewise, certain
unmarried
grounds of
couples
divorce,
cannot jointly
conviction of
adopt a
husband
child.
for bigamy,
Though
rape,
the additional
etc.,
criteria prescribed by
entitle
the
the wife
CARA
additional
circular
grounds.
would also affect
Other
a
provisions
heterosexual person's eligibility
enact
to adopt a
separate
child.
degrees
It would
of
disproportionately
prohibited
affect
relationships.
non-heterosexual couples.
Section 4C
This is because the
uses
state has
the
not
term
conferred legal
husband and
recognition
wife.
to the unions between
There are
queer
other
persons in the
provisions
form of marriage.
which deal
Consequently,
with
an unmarried heterosexual
which
couple who wishes to adopt a
specifically
child
use
has
gendered
the option
terms.
of marrying
The
and
general
marrying
pattern of these
to meet the
provisions,
eligibility
including the
criteria for
specific
adoption.
provisions
However,
enabling
this
or
is not an option for queer
entitling
couples.
women
When the CARA circular is
certain
read in the
benefits
light
in the
of this
effect
legal
of
position,
sections
a person of the
19
queer
to
community
21A
would be
is
forced to
that
choose
even
between
if
their
for
wish to be
argument's
an
sake
adoptive parent
it were
and
accepted
their
that
desire
section
to enter
4
into a
could
partnership
be
with a
read
person they feel
in
love and affinity
gender-neutral
with.
terms, the
This
interplay
exclusion
of
has the
other
effect of
provisions which
reinforcing
could
the
apply
disadvantage already
to
faced by the
such
queer community.
queer couples
For
in
these
such
reasons and the
cases
reasons
would lead
recorded
to
in section
anomalous
D so and
results.
so, the CARA
Results
circular
rendering
is
the
violative
SMA
of Article
unworkable.
15 of the Constitution.
It is important. Now there's a section that deals with the discriminatory impact on queer couples. It is important to recognize that while the state ipso
I
facto
would
may have
address
no role
myself to
in the choice
my
of two
disagreement with,
pre-built individuals
the
to marry,
scholarly
it's
judgment of my learned
characterizing
brother,
marriage
Justice
for
Bhatt.
various collateral
My learned brother
and
relies on the
intersectional
example of Article
purposes, such as
19(1)d to
permanent
buttress
and
this point.
binding legal
He
relationships
states that in the absence of a
recognized
law
as
which
such
casts a
between
duty on the state to
heterosexual
provide
couples only
transportation through
and
roads,
no other
a citizen cannot approach
impacts
the court
queer
and seek the
couples
construction of a
adversely.
road to enforce the
The
right to
intention
move
of the
freely.
state in framing
The
the
opinion of my
regulations or
learned brother
laws
fails
is
to
to
have
confer
noted the judgment
benefits
of a
to
three-judge bench
families
of this court
or
in the
individuals
state
who
of
are
Himachal
married.
Pradesh
This
versus
has the result of
Ume Ram
adversely
Sharma.
impacting the
I'll
queer
not read
couples.
the rest of
By
that.
recognizing
Contrary to what is stated in the
heterosexual
judgment of
couples union
Bhajje,
and
the directions in my
cohabitation as
judgment
marriage,
do not
marriages
require
in
the
various
state to
laws
create
and
a social or
regulations,
legal
as in
status or a
employment
social
or
institution.
nominations in
The
pension,
directions are with a
provident
view
fund,
to
gratuity,
recognizing
life
the
and
choice
personal
that a
accident
person makes
insurance
for
policies,
themselves when they choose
for
another to
credit,
be their partner
particularly
for life.
joint loans to both
The
spouses,
directions seek to make that
based
choice
on
a
their
meaningful
total
one.
earning capacity,
Nowhere do they
for
create an
purposes of
institution of any
receiving
kind.
compensation
Rather,
in
they
the
give
event of
effect to the
fatal
fundamental
accidents,
rights in
to
Part 3
name
of the
a few,
Constitution.
and not
This is the
providing for
mandate of this court under
non-heterosexual
Article
couples
32,
results in their
which says that
exclusion.
the Supreme Court
The
shall have the
individual
power to
earned
issue
benefits by
directions or
each
orders or
partner
writs
or
for the
both
enforcement of any
collectively,
of the rights
which
conferred
would
by
be
this power.
available to family
No
members,
response is forthcoming
such
to my
as
detailed
employee state
exposition of the
insurance
scope of the powers of
benefits
this court under
in
Article
the
32.
event of
In
injury of an
section
earning
D1 of my
partner,
judgment,
provident fund,
in fact, Justice Bhatt
compensation,
himself
medical benefits,
recognized
etc.
that
are
courts often
examples of
enable
what
and
the
oblige the
injured or
state to take
deceased
measures.
partner,
My
by
learned brother
dint of
also arrives
her
at the
or his work,
conclusion that the
became
state is indirectly
entitled to,
discriminating
or the
against the queer
members
community,
of her
but
family
fails to
became
exercise the
entitled to.
power vested
The
in this
denial
court
of these and
by Article
inability of the
32
earning
to
partner
alleviate this
in a queer
discrimination in any
relationship,
way. This
therefore,
court is not through
has
judicial
an
diktat
adverse
creating a legal regime
discriminatory impact.
exclusively for
The state
persons
may
of the
not
queer
intend the
community,
discrimination
but
or
merely
exclusion in
recognizing
the conferment of such
the
benefits
duty of the state
or social
to
welfare
recognize
measure.
the
Yet
entitlements
the framework
flowing
of
from
these
exercising
policies
the right
expressed
to
in
choose
favor of
a life
those
partner.
matrimonial
Page
relationships
234.
results in denial of entitlements despite the professional
The
abilities
judgment
and
of my learned
contributions
brother
which the
contradicts
individual
itself when he
might make
holds
to
that the
society.
SMA is not discriminatory by relying on its
The
object
objective
on the
of
one
many of
hand,
these
and
laws
that
or
the state
schemes
has
is to confer
indirectly
or provide
discriminated against the queer
entitlements
community
based on
because it is
individual
the
earning
effect and not the
contribution.
object which is relevant
For
on the
example,
other.
Provident
My learned
Fund
brother
is payable
discusses
to
in detail the deprivation,
due to the
exclusion,
employee's
and discrimination
personal
faced by the queer
contribution
community.
and status as
In effect, he
employee.
firstly recognizes
Similarly,
that they have a
objective
right not to be
entitlement of
discriminated
benefits of
against, and secondly
employees,
holds
state
that
insurance,
the actions of the
etc.,
state have the
flow
effect
from
of
individual
discriminating against
status,
them.
work and effort.
However,
Major
it does
part
not
of
take the
these
step
benefits
which
or all
logically
of them
flows from such a
in the
ruling,
event
which is
of
to pass
certain
directions to obviate such discrimination and ensure the
eventualities such
realization
as
of the rights
fatal
of the queer community.
accident or death.
I cannot bring
The
myself to
design
agree
of
with
these
this approach.
statutes and schemes is
The
to
realization
enable
of a right
both the
is
concerned
effectuated
subscriber
when there is a
or
remedy
the
available to
employee
enforce it.
to receive
The
them,
principle of
or
to
in
be
an
just, to be
unforeseen
remedium,
event such as death,
that is an
for his
infringement of a right
dependents
as
to
a
receive
remedy,
them.
which has
The
been applied in the
restrictive
context
way
of
in which
civil law
dependent
for
or
centuries
nominees
cannot be ignored
excludes
in the
their
constitutional
enjoyment to the
context.
intended beneficiary.
Absent the grant of remedies, the formulation of doctrines is no more
Addressing
than
all
judicial
these aspects and
platitudes.
concerns means considering a
In view of
range
the
of
deeming
policy
fiction created
choices
by Section
and
12 of the
involving
Hindu Adoptions and
multiplicity of
Maintenance Act
legislative
1956
architecture
and
governing the
Section 63 of
regulations
the JJ Act,
guided by
an
diverse
adopted child is
interests
a
and
legitimate
concerns,
child of the adopting
many of
couple.
them possibly
The manner of
coalescing.
determination of
On
legitimacy
3rd of
prescribed by
May
Section 112 of the
during the
Indian
course of the
Evidence Act
hearing,
shall
the
not
learned
apply in view of the
Solicitor
deeming
General upon
fiction created by
instructions had
Section
expressed
12 of the
union's
Hindu
position
Adoptions and Maintenance
that a
Act
high-powered
and Section
committee
63
headed
of
by
the
the
JJ
Union
Act.
Cabinet
Thus,
Secretary
all the
would
benefits
be
which are
formed to
available under the
undertake a
law to a
comprehensive
legitimate child
examination
who has been
to
validly
consider such
adopted of a
impacts
married couple
and make
will
suitable
equally be available to the
recommendations
legitimate
in
child
that
of an
regard.
unmarried couple. For example,
So
Section
we
20 of
proceed
the
to
Hindu
agree
Adoptions
with
Act,
the
which
learned Chief
provides that a Hindu is
Justice's
to maintain their children,
conclusions with
does
regard
not
to
make any
the
distinction between a legitimate child of a
right
married
of
and unmarried couple.
transgender
Similarly,
persons
succession
in
law in India does
heterosexual
not
relations
differentiate between the
to
child of a
to
married
marry
and
under
unmarried couple
existing laws.
if the child has been adopted
On
by
the issue
following the
of
due process of law.
adoption,
Further, the breakdown of the
uh,
relationship of an
we-
unmarried couple will
we
not lead
express
to a
our
change in applicable law
disagreement
because the child will continue to be a legitimate child
and
even
voice
after the
our
breakdown of the
concerns
relationship.
in the following
It is
manner.
therefore unclear what the disastrous consequences referred to are. My learned brother has also failed to address whether Regulation
We have
5.3 is
voiced our
discriminatory
concerns
for
and,
distinguishing
laid it
between
out in
married and
some
unmarried
detail,
couples for the purpose of
which I do
adoption
not wish to,
and for the disproportionate impact that it has on the members of the queer community. While
This is not to say
holding
that
that the state
unmarried
cannot on
couples,
any
whether
account
queer or
make regulations that
heterosexuals,
are
are not
facially or
capable
indirectly
or
discriminatory
suitable to be
on the
adoptive
ground of
parents. However,
sexual
once the law
orientation.
permits,
I'll
as
pronounce
it
my
is done,
directions.
adoption by both
The first part of my
single
directions are
individuals,
directions to
the
obviate
likelihood of their
discrimination.
joining and cohabiting cannot be ruled out.
Counsel for the
In such
petitioners
event,
and
de
some
facto
counsel for the
family unit
respondents
can and
advance
does come about.
extensive
The
submissions on
underlying
the various
assumption in
forms
the
of
law
violence
as
and
exists
discrimination
is that such
that
unmarried,
society and the state machinery
heterosexual or
inflict
queer
upon the
couples
queer
should
community
not adopt.
and especially
It
queer
needs to be
couples.
closely
This has
examined.
been discussed in detail
Similarly,
in the
the needs
prefatory
of
part of
such
the
couples
judgment.
to have and
Counsel
raise a
sought
family in every
directions to
sense of the
obviate such
term
violence and
is to be
discrimination.
accommodated
Now
within
my
the
directions.
framework
A.
of the law.
The
The
union
existing
government,
state of affairs
state
which
governments
permits
and
single
governments of union
individuals to
territories
adopt
are
and later
directed to
reverse a
1.
couple in
Ensure
exercise
that
of
the
their
queer
choice,
community
in
is
effect
not
deprive the
discriminated
children of
against
such
because of their gender
relationships,
identity
various
or
legal and
sexual
social
orientation.
benefits which are otherwise
2.
available.
Ensure that
Given
there is no
the objective
discrimination
of,
access to
to a
goods
married
and services
couple.
to
In
the
other
queer
words, given
community,
the
which are
objective of
available to the
Section
public.
57,
3.
the state as
Take steps
parents
to sensitize the
needs
public
to
about
explore
queer
every
identity, including that
possibility
it
and
is
not rule
natural
out
and not a mental
any
disorder.
policy or legislative
4.
choice to ensure
Establish hotline numbers that the queer
maximum
community
welfare
can
and
contact when
benefits
they face
reach the
harassment and
largest
violence
number
in
of
any
children
form.
in need of
5.
safe and
Establish
secure
and
homes with a
publicize the
promise for
availability
their
of
fullest
safe houses
development.
or garima grahes in all districts to provide shelter to members of the queer community who are facing violence or discrimination. 6. Ensure that treatments offered by doctors or other persons
response
which
to
aim to
the
change gender
Learned
identity
Chief
or sexual
Justice's,
orientation are seized with immediate effect. 7.
comments on
Ensure that
on our
intersex children
draft,
are not forced to undergo
which
operations
I
with regard
propose to
only
be
to their sex,
part of which is
especially at an
supposed to
age
be
when they are unable to fully comprehend and consent to such operations. 8. Recognize the self-identified gender of all
This
persons,
court's
including
observations with
transgender
respect to the
persons,
learned
hijras,
Chief
and
Justice's
others,
reasoning
with socio-cultural
centered
identities
around
in
the
India as
enunciation
male,
of the
female, or
bouquet
third
of
gender.
rights emanating
No
from these
person shall be
provisions
forced to undergo
and
hormonal
locating
therapy
an
or
obligation
sterilization
has to
or
be
any
seen in
other
the
medical
backdrop of
procedure,
the
either as a
unanimous famous view of
condition
this
or
court
prerequisite to
that
grant
the
legal
fundamental
recognition
right to
to
marry
their
is
gender
not
identity
found
or
within the
otherwise.
Constitution.
B.
Therefore, it
The
is our
appropriate
considered
government under the
opinion
Mental
that to
Health Care
create an
Act must
overarching
formulate modules
obligation upon the
covering the
state
mental health of queer
to
persons
facilitate
in their
through
programs under
policies
Section
the
29(1).
fuller enjoyment of rights
Programs to reduce
under
suicides
Articles
and attempted
19 and
suicides
25
envisaged by
is
Section
not rooted in
29(2)
any part,
must
past
include provisions which
decision or
tackle queer
jurisprudence.
identity.
That
C.
queer
The
couples
following
have the
directions
right
are
to
issued to the
exercise
police
their choice,
machinery.
cohabit
1.
and live
There shall
without
be no harassment
disturbances
of queer couples by
incontestable.
summoning them to the
In the
police
same
station
vein, that
or
they are
visiting
owed
their
protection
places of
against any
residence
threat
solely to
is the
interrogate
natural
them about their
corollary
gender
of their right
identity
under
or sexual
Article 21.
orientation. 2.
Consider in this
They shall
context
not force
also the
queer
nature of relief
persons
sought
to return to
and
their
the
native
positive
families if they do
obligation
not
fashioned.
wish to return to them.
Whilst
3.
there are
When a
innumerable
police
judgments
complaint
on
is
the
filed by
positive
queer
contents
persons
of the
alleging that
rights
their
under
family is
Article
restraining
21,
their freedom of
there
movement,
are countless
they shall, on
judgments
verifying the
that
genuineness
insist
of the
upon the
complaint,
separation
ensure
of
that their
powers
freedom is not
when it
curtailed.
comes to
4.
matters of policy,
When a police
and
complaint
the
is
courts
filed
not being the
apprehending violence
appropriate
from the
forum
family for the reason that the
adjudication of the
complainant
same.
is queer
The
or is in a
polycentric
queer
nature of
relationship,
this issue is
they shall,
compelling.
on verifying the genuineness of the
Next,
complaint,
as to
ensure
the
due protection.
reasoning
And 5.
that our
Before
conclusion on the
registering an
challenge
FIR
of
against a
SM
queer couple
and
or one of the
subsequently
parties in
finding
a
on the
queer
disparate
relationship,
discriminatory
where the FIR
impact
is
faced
sought
by
to be
the queer
registered in
community,
relation to their
a
relationship,
small
they
comment
shall
is
conduct a
called for.
preliminary inquiry
The section
in terms of
discussing the
Lalita
provisions of
Kumari
the
versus
SMA and
Government
the
of
challenge
UP
to its
to ensure
validity
that
was
the
based
complaint discloses a
upon whether it
cognizable offense.
violated the
The
Constitution
police
on the
must
ground of
first
impermissible
determine if the person is
classification
an
under
adult.
Article
If the
14,
person is an adult
which
and
the
is in a
object of the
consensual relationship
act
with another person of the same or
facilitate
different gender,
marriage between
or has
interfaith
left that
couples,
natal home of their own
wherein the
volition,
at the
the
time
police shall
marriage
close
or
the
even a
complaint
couple
after
only
recording a
denoted
statement to this effect.
heterosexual couples in the light of
Conclusions
same-sex
and orders of
relationships being
enforcement.
criminalized and its
In view of the
provisions
discussion
are
above,
relevant factors.
The following are the
Classification
conclusions.
involves differentiation.
This court
Further,
A,
this court has
this
discussed
court
how
is vested with the
underclassification
authority
per
to
se
hear this
does not
case.
warrant invalidation.
Under Article 32,
In
this court has
contrast,
the
in the
power to
later
issue
segment
directions,
on
orders, or
discriminatory
writs for the
impact,
enforcement of the rights in
the
Part
issue
3.
that this court was
B,
considering
Queerness is a
was
natural
not
phenomenon
reasonable
known to India
classification,
since
but
ancient
impact upon
times.
queer couples through
It is
neutral
not
laws
urban or elite.
or regulations that
C,
they encounter.
There is no
in their
universal
everyday
conception
lives,
of the institution
the
of
purpose
marriage,
of which or even their
nor is it
substantive
static.
provisions
Under
have
Articles
nothing to do with
245 and
marriage.
246 of the
It
Constitution,
is
read
rather
with
to
entry
confer
5
other
of List 3
benefits,
to the 7th
many
schedule.
of which are
It
earned
lies
or
within the
accrued on
domain of
account
Parliament and the
individual
state
skill.
legislatures to enact
Yet
laws
the framing of these
recognizing and
benefits
regulating
or
queer
their
marriage.
intended
D,
beneficiaries
marriage
were
has attained
articulated
significance as a legal
in terms of
institution largely because
entitlement
of
to
regulation by
families
the
or
state.
spouses.
By
It tends
recognizing
to
a
exclude
relationship
from
in the
its
form of
ambit queer
marriage,
couples.
the state
When
grants
such queer
material
couples are
benefits
entitled to
exclusive
benefits
to marriage.
wherever they fulfill
E,
other
the state has an
eligibility
interest in
criteria,
regulating the
it is the
intimate zone
disparate
to
impact of
democratize
these
personal
neutral laws
relationships.
in the
F,
disbursement of
the
entitlements
issue
or
of whether the
benefits which is
Constitution
soon through
recognized
the
the right
effect
to
or
marry
impact lens.
did not arise before this
Therefore,
court
the
in Justice
discussion on
K.S. Puttaswamy, 9
constitutionality of
judges,
SMA
Shafin Jahan and
is
Shakti
markedly
Wahini.
different from the
G,
section on
The
discriminatory
Constitution
impact
does not
in
expressly
certain
recognize a
points
fundamental
for
right to
queer
marry.
couples as they
An
have no
institution
avenue for
cannot be
marriage like
elevated to the realm of
heterosexual
a
couples.
fundamental right
In the latter,
based on the
impact
content
of
accorded
various
to it by
laws were
law.
pointed as
However,
starting point
several
for the state
facets of the
to
marital
take
relationship
remedial action.
are reflections of constitutional values, including the right to human dignity and the right to life and personal liberty. H. This court cannot either strike down the constitutional validity of the Special Marriage Act or read words into the Special Marriage Act because of its institutional limitations. This court cannot read words into the provisions of the SMA and provisions of
sorely
other laws,
mistaken if we
allied
presume
laws such as the Indian Succession
what
Act
the
and the
queer
Hindu
community
Succession
in all
Act,
its
because
diversity
that would
seeks
amount to
and lays
judicial legislation.
it
The
out
court,
as a
in the
formaic
exercise of the power of
framework.
judicial review,
Many
must
may
steer
welcome
clear of
civil
matters,
unions as a
particularly those
pragmatic
impinging on
first step,
policy,
while
which
some
fall
may
in the
find it
legislative
yet to
domain.
be another
I,
inequitable solution
freedom
to
of
the feeling
all
of
persons,
exclusion
including
that
queer
persists
couples,
in society
to
against
enter
this
into a
community,
union
and one
is
which
protected
simply
by Part 3
repackages the
of the
stigmatization
Constitution.
felt.
The
Many may
failure of the
desire
state to
marriage as
recognize the
understood in
bouquet
the
of
traditional sense
entitlements
to escape
which
their
flow
social
from a
societal
union
realities,
would result in a
a form of
disparate impact
financial
on
and
queer
social
couples who
emancipation
cannot marry under the
from
current
opposing natal
legal
families,
regime. J.
or diametrically
In
opposite
Article
to assimilate and
15.1,
gain more
the word
social
sex must be read to
Yet
include
others
sexual
may, as a
orientation,
result of their
not only
experience,
because of the causal
reject
relationship between
altogether the
homophobia and
institution of marriage
sexism,
and
but also
all the
because the
social
word sex is
obligations
used as
and
a marker of
associations that
identity,
come with it,
which cannot
but
be read
still
independent
want
of the social
protection
and
of their
historical
rights.
context. K.
Certainly what
The right
former
to
group
enter
may
into a
want does
union
not hamper
cannot
or
be
hinder the
restricted
latter in
based
any
on
manner,
sexual
for it
orientation.
is a choice
Such
that
a
they
restriction
seek.
will be violative
But the
of Article
state should
15.
facilitate this
Thus,
choice
this
for
freedom
those
is
who wish
available
to
to all
exercise it,
persons,
is an
regardless of
outcome
gender
that the
identity
community
or sexual
may agree
orientation.
upon.
L.
Yet the modalities
The decisions
of
Decisions
how
in
it should
Nappage
play
and
out,
Justice K.S.
what it will
Puttaswamy, 9
entail,
judges,
are facets that
recognize the
state,
right of queer
where the
couples to
legislature
exercise
and
the choice to
executive
enter
needs
into a
to
union.
exercise it past
This relationship is
furtherance of.
protected from external
Now,
threat.
whether this will happen
Discrimination
through
on the basis of
proactive
sexual
action of the state
orientation
or as a
will
result
violate
of
Article
sustained
15.
public mobilization.
M. Transgender
reality
persons
that
in
will play out
heterosexual
in India's
relationships
democratic
have the
state
right to
is
marry under
something only
existing
time
law,
can tell.
including
The
personal
state may
laws
choose
which
from a
regulate
number of
marriage.
policy outcomes.
And
They may
intersex
they may
persons who
make all
identify
marriage and
as
family
either
related
male or female
laws gender
have the right
neutral,
to marry
or
under
may create a
existing law,
separate
including
SMA-like
personal
statute
laws which
in
regulate
gender
marriage.
neutral terms.
O.
To give the
state
queer
must
community an
enable
avenue for
the
marriage. They may
LGBTQ
pass an
community
act
to
creating
exercise
civil
its
unions
rights
or
under
a
the
domestic
Constitution.
partnership.
Queer
Among the
persons
many
have
other
the right to
alternatives.
freedom from coercion
Another
from their
consequence
natal
may be that
families,
rather than the
agencies
union,
of the
the
state,
state
including the
legislature
police
takes
and other
actions
persons.
or
P.
enacts law.
Unmarried couples
What